the preparation a different for arbitration when compared to litigation?
Oh yes.
Prepare?
Oh yes. So when you go to a court, now arbitration is also domestic and international. How a domestic arbitration will work is completely different from how an international arbitration works. Your domestic arbitration, especially in a country like India, pretty much goes like a trial only. It's just that the legislature has put a 6-month timeline to complete the pleadings and then 1 year to complete the arbitration on our heads. Otherwise, it would have gone. There are arbitrations that I'm doing which are still going on, and they are 2008, 2009 arbitrations. So, I actually feel that the preparation is very different because in courts, there are a lot of times when you don't get deep into a proposition because you know the judges would know it. So if there's a section 20 principle, you know that the judge would know it. You would just open your bare act, section 20, maybe one judgment, and it's done. When it's an arbitral tribunal, especially of 3 arbitrators, everybody's thinking differently. Usually so if it's an ad hoc arbitration of a single member, it's even riskier. But if it's a 3-member, ad hoc or institutional, you may have one person who's from a district court in Kerala, one person who's from another district court somewhere, or a high court judge. Now, a lot of those people may not have actually practiced on the civil side ever in their lives. But we are traditionally used to appointing arbitrators who are retired judges, depending on the stakes. If the stakes are very high, we usually go in for High Court, Supreme Court judges. But there are a lot of times you have district court judges also. And even in High Court judges, sometimes we felt that we've had to dive deep into issues as basic as jurisdiction, which is section 16 at the beginning of the arbitration, to convince the tribunal that this is not a part of the same arbitration agreement is also a big ask. And then the orders that come in, then you go to court, multiple rounds of litigation. So with a tribunal, you have to, it's actually the art of persuasion. You have to persuade them that what you're saying is correct. So once you have to persuade them, your research and your work has to be very, very thorough as compared to a court where even a very basic drafting with just one judgment in hand can get you a good result as compared to an arbitration.